Welcome back. Be seated, please. All right, the next case we have is G versus U.S. Bank. Good morning.
Good morning. May it please the court, my name is Enrique Nieves with ICE Legal. I represent the appellant, Jennifer G. I would like to reserve 8 minutes for rebuttal.
Is it a cold place to work there? Or?
My last name's Nieves. It's snow in Spanish, so it's ice and snow.
All right.
But this is an appeal from a summary final judgment. Therefore, the standard of review is de novo. The summary judgment standard is well known. U.S. Bank had the burden of showing through admissible evidence that there was no genuine issue of material fact that it owned and held the note mortgage at the time of filing. And it failed to do so because the note is specially endorsed to option 1. The mortgage lists Advent Mortgage as a mortgagee. Just to give a little background, I'm not sure how familiar everybody is with the facts, but the case was filed in May of '09. There were several counts.
You can assume that we're well familiar with the facts.
Well, let me ask you, Mr. Nieves, as I understand the way the paper went, Ms. G signs a note mortgage in favor of Advent. Advent assigns it to option 1. And the next document I see of record is from American Home Mortgage Servicing as successor in interest to option 1, assigning it to U.S. Bank. Is that an accurate history of the paper?
It's pretty accurate, and what you're detailing there is a big hole in the chain somewhere between option 1.
Well, that's what I'm trying to understand is what evidence in the record is there, if any, that would suggest that when American Home signs an assignment to U.S. Bank, it signs it as American Home as successor in interest to option 1. What evidence in the record is there that they are in fact a successor in interest, by, I don't know whether it's by merger, acquisition, what is it? They just sort of pop in.
There's nothing in the record. And before we would even get to that, the assignment wasn't authenticated. It's not even admissible by itself. It was filed and accompanied with nothing that authenticated. No affidavit ever mentioned the assignment of mortgage. It was never sworn to as a true and correct copy of anything. So I guess once you get past that step, assuming it was authenticated.
Yeah, looking at the merits as opposed to the authentication issue. Is there anything in the record that shows where American Home Mortgage comes from?
There's nothing at all in the record. It just shows up with the assignment, and even looking past that, assuming let's say it said option 1 to U.S. Bank. Let's say that was the assignment. It still leads to reversal because under WM Specialty there's a conflict on the face of the assignment. The problem here is that on the day the complaint was filed, there was no assignment. None existed. And it said assignment to be recorded is what they were basing their ownership on. But what it should have said was assignment to be created.
Wasn't there assignment, didn't they come up with an assignment that was retroactive back to...
And that's the conflict on the face of it. And I do receive from one point in the initial brief, there was some argument about Jeffrey. And when I was looking at it over again, I don't think the Jeffrey argument applies, but Jeffrey is an important case in the line of cases leading up to WM Specialty. Because in Jeffrey they had the same issue, except there wasn't an effective date. There wasn't an inconsistency. So because of the late filed assignment, the court there held that you couldn't acquire a cause of action after the suit was already filed. You can't acquire standing later. And so WM Specialty came up, and in the lower court, the court did the same thing. It was same situation here. The court dismissed the case. And then when it went up to the 4th District, what the 4th District did was that they cited to Johns v. Gillians, which is an old Florida Supreme Court case, where there was an assignment that was defective because it's some corporate seal or something. Either way, it was defective. And all the facts were outlined in Johns. So what the court there said was, even though it was defective, we're going to hold that they had an equitable interest from the assignment that And what's important about Johns is there was an evidentiary hearing. The court there repeatedly cites to record transcripts of the owner saying that they had this interest before the complaint was filed. So what WM Specialty did, they took this same situation, pretty much the same situation we have here, post-suit assignment with an effective date, and said there's a conflict on the face of this assignment, and this conflict should be resolved at an evidentiary hearing.
One of the claims that the bank brought was to reform the deed and mortgage.
It was to reform, to reestablish a lost note, to reestablish a mortgage, to reform the mortgage, and to reform a deed.
So I guess the bank's position was that when Ms. G acquired the property, and that the original legal description from the prior owner was erroneous, and that erroneous legal description got picked up in the mortgage. That was essentially what
they I think provide what they suggest is a corrected version.
Was the Miss G's predecessor in interest, the grantor in her deed, made a party to the litigation?
I do not believe so. I don't think there was any other previous owners on that side that were made a part to the litigation. And our point was, I wasn't involved in the trial case, but on appeal, our point was, as far as reformation of anything, nothing was raised by motion, nothing was mentioned in the affidavit, and nothing was raised at the hearing. So what happened was, after this hearing where some other things were raised, what U.S. Bank did was they just changed the legal description without moving for it, without asking for it, and without stating anything through an affidavit about any reformation. So what it amounted to was either they tricked the lower court or the lower court granted a sua sponte summary judgment. Either way, it has to be reversed. But the bigger point, to get back to the merits, is what we were talking about with the note. The note, because it's specially endorsed to option 1, U.S. Bank simply just can't be the holder. They would have to, two things would have to happen under the UCC. There would have to be negotiation. It would have to be endorsed either to U.S. Bank or in blank. Neither happened. And there would have to be some physical transfer and delivery of the note. Nothing in the record shows that, and in fact, it pretty much shows the opposite. So
wouldn't the assignment, if we assume for the sake of my discussion that the assignment that was signed as American Home Mortgage as successor in interest to option 1, which purported to make it retroactive to a date that preceded the filing of the mortgage, wouldn't that assignment, if they had the authority, wouldn't that assignment act to transfer that note and mortgage?
No, because exactly what I spoke about in the WM Specialty case. There's a conflict. So what we have is an assignment that was created. So anywhere in between the filing and the creation of the assignment, a motion to dismiss would have dismissed this case. So after they created the assignment, what we have here is the actual execution date coupled with a self-serving effective date.
Well, but just work with me here for just a minute. The purported assignment, what they're trying to say is, look, we agreed that we signed it after the lawsuit was filed, but we really transferred it before the lawsuit was filed. And if they, in fact, transferred it before the lawsuit was filed, they might have standing. But my point is, forget the timing of it for a moment. Let's just assume that that's not the problem. That all we're trying to focus on is the legal effect of the assignment itself. Would the assignment transfer the note and mortgage from option 1 to U.S. Bank if, in fact, American Home Mortgage is the successor in interest to option 1?
Yes, if they could somehow show that they got from option 1 to American Home Servicing, and then they would have to show that it.
Okay.
assignment that would go.
So we're really trying, your focus then is on two issues. One is the timing, that even if option one had the authority to do it, they didn't do it in time, so they had no standing at the time the lawsuit was filed. That's your first point. Your second point, though, is, if I understand it correctly, you don't dispute that if in fact American Home is some sort of successor in interest to option one, that the assignment would have the effect of transferring the note and mortgage to U.S. Bank.
I do not dispute that if they were able to testify as to this chain of title, that
I'm with you.
maybe, but the fact that there's no testimony, there's no affidavits, and because of the case law says there needs to be an evidentiary hearing to resolve this conflict. So it would go back toward John v. Gillian's, where you would need an evidentiary hearing so somebody can actually testify and say that this stuff went where it was supposed to go to. And I guess the other point is an assignment wouldn't make U.S. Bank the holder of the note. So they can't be a holder. I spoke earlier about what the UCC requires, and that's just not present here. And to move on, I want to talk about the affidavits, because we talked about what they would have to testify to. They didn't. And the affidavits, what they do say is very little, and they violate Rule 1.510E in that they don't attach parts or papers referred to in the affidavit. They don't attach one of certified copies.
Was that raised? I know that, is it G? How's that name pronounced? G. That Ms. G represented herself and made some general objections, but was that raised?
As far as it was raised by on the motion for rehearing, yes.
Right. That was the first time after summary judgment.
But if you look at summary judgment, there was some problems with that, because there was argument made to the judge before G was actually present in the courtroom. So if you read the transcript, there's argument made
she was apparently late getting there,
urging the judge to do certain things, and when G showed up, the judge would not consider any argument, even legal argument, because she couched it in an affidavit. So the judge basically said,
well, the affidavit wasn't filed pursuant to the rules sufficiently in advance of the summary judgment hearing.
But legal argument doesn't need to be filed in advance. She could have showed up that day and made legal argument, and the problem was the judge.
The judge went ahead and had a hearing. I don't know, and allowed her to make argument.
Well, and the judge, I mean, he stated what standard he was under. He said, unless you say you paid this, this is granted. So he didn't consider anything. He didn't consider the affidavits. He didn't consider anything in the record. He didn't consider whether anything was authenticated. He didn't consider the fact that there's a special endorsement to somebody other than U.S. Bank. It's option one. Basically what's going on is U.S. Bank wants the rule to be just file a summary judgment motion and style it that. And then you can show up at the hearing and argue anything, sandbag, and that's all you need. Half of what was granted wasn't even in the motion. So at this point, it's clear U.S. Bank did not meet their burden. They repeatedly asked this court to depart from the rules of summary judgment, to ignore the absence of authenticated documents, and to ignore the issues of fact, including that the note was endorsed to U.S. Bank, and ignore the conflict which is controlling under Gillian and WM Specialty on the face of the assignment. And worse, they tried to slide the whole reformation issue by the court without even raising it. In this case, all roads lead to reversal, whether it's procedurally or substantively. Summary judgment must be reversed. Thank you.
Thank you, sir. Good morning.
Good morning, and may it please the Court. Your Honors, my name is Ron Gachet, G-A-C-H-E. I'm with the law firm of Shapiro, Fishman, and Gachet, and we have been asked to handle the appellate aspect of this matter, the oral argument aspect of this matter. The Gladstone law firm handled the lower court proceedings. A lot of what Mr. Nieves says is actually correct. Let me start by saying that. But what he doesn't impress upon the Court, and for good reason, is that a lot of this was waived below. A lot of this was waived in the borrower's pleadings. Let's start with the fact that Ms. G filed no affirmative defenses whatsoever in this action.
But
Standing is
she
an
didn't file a general denial that just said, I deny everything.
Well, she filed denials and then some explanations. I'm going to get into that in the answer, Judge.
But one of the allegations that your client makes below is that we own and hold the note, and she denies it. Right?
The word denied appears in the answer.
Okay.
With
So
some caveats.
All right. Help me understand, as I look at the instruments.
And you were right, by the way, on the paper, on the trail.
Right.
You
The
had that.
gap that I see, if there is a gap, is we have the note in option 1, and the next instrument is American Home as successor in interest to option 1. But there's nothing in the record that would support American Home. There's no affidavit that says we're successor by merger or acquisition or anything. They just show up out of nowhere and sign this document. And so help me understand how that establishes that your client is really the holder of the note.
Well, it is a fact, not in the record, though. I will just tell you it's a fact that American Home did succeed to all the rights and obligations and responsibilities of option 1. They merged and they took over.
Well,
I agree with you.
If it's not in the record,
No, I agree with you, it's not.
As far as we're concerned, it's not a fact.
Right, but I agree with you, it's not in the record. The point is, it's in a notice of filing in the assignment of mortgage that's filed. It's then reiterated in the affidavit of indebtedness. If indeed that's a lacking argument, it was incumbent upon Ms. G to move to strike or to raise that issue at the trial court below. Because if you don't, maybe it's a matter of public knowledge. Maybe it's a matter that Ms. G understands and says, I get it. There was a merger. I know about it. You don't have to support everything.
Even at the summary judgment hearing, she disputed who actually owned the note.
If you look in her answer in paragraph 8.
At the summary judgment hearing, she disputed that there was proof of ownership of the note.
I don't know that she actually disputed it. If you look in her answer, which the pleadings are allowed to be taken notice of, she says, Defendant G is currently speaking with the note and mortgage holder, American Home Mortgage Servicing, Inc. She says that in her answer. That's an admission. She makes that statement in paragraph 8 of her answer. Now, all she was confused there is that American Home was the agent of U.S. Bank at that time. She says, I was talking with the note and mortgage holder. That's an admission that the court is allowed to rely upon. Paragraph 8 of her answer. So if she's just confused on agent and principal versus Advent and option 1, those were the people in the paper that she thought, or that the records showed, were in fact the original mortgagee. But she's beyond that. She's now saying that the note and mortgage holder, American Home, is who I'm dealing with. So if that's the case, all you're confused about, Ms. G, is that they're the agent. The affidavit of indebtedness and the lost note affidavit both clear that up, none of which were moved to strike at the case below. Mr. Nieves mentioned that had this case seen a motion to dismiss, it would have been dismissed outright. Well, he might be correct. The problem is Ms. G never made a motion to dismiss. She never raised it at any time at summary judgment on these issues.
Help me understand. Let me just shift gears with you to the motion for summary judgment.
Yes, sir.
When I read the motion for summary judgment, there's not one word mentioned about reformation or reestablishment. It simply says, we want to foreclose our mortgage. And when the final judgment is entered, it forecloses the mortgage, it reforms the deed and the mortgage, and it reestablishes them. Where is anything that would put her on notice that she needed to file anything with respect to the reformation and reestablishment claims in your motion for summary judgment?
Paragraph 1 of the motion says that the plaintiff is entitled to judgment as a matter of law for all relief sought in the complaint. That's what we rely on.
That meets the Rule 1.510 that says a motion for summary judgment must state with particularity the grounds upon which it's based. That's particular?
It's not as particular as I might have drafted it if I was preparing the motion for summary judgment, but A, it indicates that all relief sought, the plaintiff is going to be seeking judgment as a matter of law. B,
Do you agree that that's as close as it ever gets to the reformation and reestablishment count?
I do.
There's the words reformation, reestablishment, all that are not in there.
You've looked at it, I've looked at it, it's not there.
Okay.
That's it. It's paragraph 1.
Help me understand also, was the grantor in the deed from whoever it was to Miss G made a party to the suit below?
It was not. But
Isn't it fairly black letter property law that that person is a necessary party? I mean, the whole idea of a reformation is the intent of the parties isn't accurately reflected in the paper. The intent of the grantor was to convey Blackacre and not Greenacre.
Right.
Well, how do you know what the intent of the grantor was when you didn't make that person a party? I mean, there's a million cases out there that says if you want to reform a deed, the original parties to the deed are necessary parties.
I would agree with you that that is black letter law. That's the way we've always been taught it from law school to today. But there's procedure that goes behind that. Number one, failure to join an indispensable party is an affirmative defense, needs to be raised. Number two, the grantor who's left out. If the trial court establishes some rights in favor of the grantee without naming the grantor, his rights have not been affected. He has every right to come back in and to open up that case.
Certainly potentially messed up his title. I mean, if the grantor, in fact, intended to convey the property that is described in the deed and mortgage and not the property that you contend is in there, all of a sudden there's a final judgment out there that's screwing up his title.
I agree. It could be a real mess. There's no question about that. And if the grantor did not intend to convey that property and that property gets conveyed through foreclosure sale to a third party and title insurance is written, it's going to get unwound and they're going to have to go back to the grantor. We're assuming that it actually was the grantor's intention to divest himself of that particular property, which is the reformed legal description, I guess because that's what the underwriters and the title people who went ahead and filed this lawsuit, they saw what he did own, in fact. They did put that into the reformed
But you're relying on the conclusions of the people who messed it up in the first instance.
Well, I'm relying on the Scrivener's error, what appears to be the Scrivener's error in the mortgage and deed legal description, which we encounter all the time. Again, you're talking about an issue.
You might want to use a different title company. just some free advice.
Right, I get that, I understand. I don't know that the title claim hasn't been made. I'm not sure what extraneous proceedings are going on. But I will tell you that in this particular situation, an issue that you're raising is certainly not an issue that's before the court framed by any pleadings today, or that I'm more prepared than what I've just done with you to exchange the information, because I don't know what the grantor's position is. I don't know if anyone ever actually spoke to the grantor, the title company, there might be a title claim, we don't know. But because it's not injected.
And again, I recognize that you didn't try the case.
Yes, sir.
You agree that to do this right, if you really want to reform that deed, the original grantor is a necessary party.
I believe that in order to avoid the problems you're talking about down the line, you should have the grantor, and he should have been named.
So if the case gets sent back, that's a good footnote to put in.
That's a perfect footnote to put in, and indeed, if I can tell you, if my law firm is asked to handle the re-foreclosure of this matter, the grantor would certainly be added as an additional party. But that said, that's really something for the parties to work out at another date and time. I don't know that it's this court's job to go ahead and protect the interests of parties who are not here, or to look out for people that are not part of the issues of this case. What I'm focusing on today is whether or not there was sufficient evidence and record evidence and procedurally proper to enter summary judgment in this case. There was no affidavit in opposition because we can't count on the one that was stricken. There was no affirmative defense of standing raised. The lost note affidavit makes clear that every allegation in the complaint is true and correct. There was never any contra testimony to that.
Can issues be raised for the first time on a motion for rehearing?
I don't think so. I think a rehearing, the whole purpose of a rehearing is to apprise the court of something that it missed, something that it didn't apprehend, something that for one reason or another was argued, but the court just for some reason didn't get or understand the argument. You don't wait until summary judgment is over, 10 days later move for rehearing and raise issues. What would be the point then of the 2- and 3-day advance requirement for affidavits in opposition and those types of things?
Put factual issues in dispute. The motion for rehearing is potentially arguing legal issues.
I probably could cite to a number of appellate decisions in this court and others that say, listen, don't come back to us with a rehearing to re-argue matters. And I don't think that you should have an opportunity to re-argue or argue something you missed the first time around. I would note that Ms. G is an attorney, not that that makes a difference, but she decided to represent herself. She was late to the hearing. She made the arguments. I've read the transcript multiple times. She was given every opportunity to tell the court about her woes and to tell the court about her situation. She chose not to focus on moving to strike affidavits or giving any indication that her answer was incorrect or wanting to amend or wanting to add indispensable parties. OMSI signed, the OMSI is American Home Mortgage Servicing, OMSI signed the affidavit of indebtedness as the servicing agent. They stated in the affidavit of indebtedness that every allegation of the complaint was true, and they indicated that U.S. Bank owns and holds the mortgage and that the defendant in fact defaulted.
Well, I have an interesting question about that. Didn't that affidavit also say in paragraph 7 that the original note and mortgage will be filed?
It did. I consider that.
So how do we get from, in your pleadings, you say, we've looked everywhere. We have turned the world upside down to find this, and we can't find it. And so we want to reform and we want to reestablish. And at the very same time, you know, you're talking about all their pleading deficiencies, which admittedly are numerous. But, you know, you say in your affidavit of indebtedness, the original note and mortgage will be filed at the hearing, and yet in your affidavit of lost instruments, we've looked everywhere and we can't find it. I mean, you know, it's got to be one or the other, and you file the things at the same time from the same, I think they were both signed by OMSI.
I think where you're finding the statement that the note will be filed is actually in the motion itself signed by the attorney.
Right.
Okay. In the motion, and quite candidly and admittedly, at this time in 2009, law firms were filing motions for summary judgment with what you would consider alternative arguments at times, or alternative statements of what they intended to argue. And in this case, firms were finding the notes sometimes after they filed the lost note affidavit. There were so many that they would find it at some point and they would file it in advance of the summary judgment hearing. That would moot or abandon the lost note claim. That was perfectly fine. But in order to be sure that if they did find it and they did file it, they wanted to have this claim that they were going to argue it in their motion. So once they don't find it...
Wasn't the affidavit of indebtedness filed along with, wasn't the affidavit of lost instruments filed at or about the same time as the mortgage motion for summary judgment?
No, my notes indicate the lost instrument was filed in August and the affidavit was October and the motion was October. So in October, they thought it was still lost. Or they knew it was still lost, but they thought they still might find it. They didn't know when the hearing was going to be. It turned out the hearing was not to be till January. So their point is, if I find it, I'm going to file it. If I don't find it, I've put you on notice of the lost note situation, and I consider paragraph 7 just simply be a nullity in the argument.
That seems like a very generous reading.
It's exactly what happened, though. I mean, they say the original...
Would this pleading fall under the fiction or non-fiction category if it was in a bookstore? I mean, it seems like they're just making this stuff up.
Well, I don't think it's much make stuff up, as they were using a lot of forms back then. I mean, they were absolutely churning out motions for summary judgment, no question about it. They had to do hundreds and hundreds at a time, and I agree. The attention to detail is certainly lacking, but if everything was still brought before the court, if we still had the proper affidavits, if indeed the note was in fact lost, if there was a waiver of defenses, if all of those things happened, it's for lawyers and judges to sort out, did it happen procedurally and materially correct such that we can affirm, or did it not? And at the end of the day, as sloppy as it may have been, or as quick and shambles as they might have been trying to push things out the door at these law firms to get things filed, at the end of the day, paragraph 7 simply says it will be filed on or before the hearing, and it wasn't. which just means that the lost note affidavit still has effect.
Now, Mr. Gachet,
Yes.
I get, and I've seen this, obviously, I was doing foreclosures in 2009, and I'm doing them again. The whole point of, pleading in the alternative, we're not sure if we're going to have the note or not, we're going to look for it, and if we don't, we're...
The whole point of count twos back then.
Of course, and usually they find it and, before the motion for summary judgment,
Right.
File it, and then voluntarily dismiss that account, trying to reestablish the lost note. But by that time, shouldn't the motion for summary judgment actually list what we're going forward on?
Well,
There's a notice, sort of that whole notice requirement.
Yes.
Specifically, what facts I'm going to put forward, and if you're pleading in the alternative, saying, well, we might be going the lost note route. All right, maybe we'll go with the note.
It's a fairness argument, I get it, and in this particular case, in October 6th of 2009, when the attorney at Gladstone signed the motion, I think they thought they may still find it. And then at the hearing, they didn't have it. So the question for this court is, does that immediately make the summary judgment invalid? Because you said in a motion you were going to bring a note, you'd already filed a lost note affidavit, so you've covered yourself, assuming that lost note affidavit is viable and it meets all the requirements. You said you were going to bring the note and you didn't. Does that in and of itself invalidate an otherwise proper summary judgment, assuming it was otherwise proper? That's really the question posed. And I don't think that putting something in a motion for summary judgment that you intend to argue and then don't argue it puts anybody in a worse position. It's just one argument less that lawyer on the other side has to deal with.
It's not an argument. It's a path to victory.
Well, we didn't say in the affidavit that we have it. That would have misled you.
The motion did.
The motion says it will be filed. I agree. But
the motion is what puts them on notice, not the affidavit.
The motion puts you on notice of the grounds to be argued. I mean, that's what we understand it to be. And in this case...
And that holds true for the reformation and reestablishment.
Absolutely.
Which we agree that...
1.510.
You were not you.
Right.
Your client was a pretty good distance away from that particularity.
Yeah, if I had to address that in closing, I would say that was harmless. I really would, because Ms. G does not in anywhere dispute that the legal description was incorrect. If you look in her pleadings and in her response and her answer, she never says, I dispute that that's what I intended to mortgage. She never says that. So equity has to be done in these foreclosure actions. If it's equitable to foreclose the right property instead of the wrong property, that's all the judge did here. She took it upon herself to foreclose the right property instead of the wrong property. Ms. G's argument, really, I know she wants reversal of the summary judgment, but she's not here arguing today that, in fact, you foreclosed the wrong property, or I didn't give you a mortgage on that particular property. We don't hear that argument. They're just using that, obviously, as an avenue to get reversal. But at the end of the day, Ms. G's been in this home since 2008 or so, in default. She admits she's in default. She says she was laid off, but she hasn't paid a mortgage payment, obviously, in 3 years and going on more. I mean, the judge just did equity at that time. And if anything, the failure to have, or the correction of the legal, but for that grantor issue that you mentioned, which is somebody else's issue today, I don't think it's this court's issue, but the grantor issue, other than that, equity was done by this judge by just simply reforming the mortgage. I agree. The Gladstone lawyer should have at least mentioned the words at the hearing, said, oh, and judge, don't forget, I want to reform the mortgage, I want to reform the deed. Something along those lines. I agree. But equity was done, and that's how we look at it at this particular time. So we'd ask you to affirm this summary judgment in all respects. Okay?
Thank you, sir.
Thank you, judges.
Mr. Nieves, is it fair to say that you agree with everything he just said? Can we just agree on that?
Pretty much. I just wanted to address a couple of quick points. As far as raising standing, I won't say I know there are cases that can be cited, because I did cite a case in Maynard v. Florida, and basically it has to be raised. It's not how you raise it. It has to be raised before, basically before it goes on appeal in the lower court. And that's actually a pretty strict reading of standing, because I know in the federal courts, if you don't have standing, if you don't have a cause of action when the complaint was filed, it doesn't matter if it's in front of the United States Supreme Court. They dismiss it. If you didn't have standing, you just didn't have it. And as far as, my next point is, as far as affirmative defenses, that's not the standard. This isn't trial. They wanted a shortcut. They just didn't want to abide by the actual rule that gives them this summary judgment shortcut. The affidavits were wholly deficient. They failed the rule. As far as this whole thing about in the alternative, it's 21 days. If you don't have them, you move. It's not like they have to do this a year in advance. So I don't buy the whole thing that if we find it, then we'll bring it. If you find it, then file another motion. The rule requires you to specify the grounds. This isn't like, should you specify? No, the rule requires that you have to specify the grounds. And I do want to, I had given opposing counsel a case that after the briefing schedule was closed, I found it when I was preparing last night. It's Conn v. Bank of America.
Did you do a notice of supplemental authority?
I will. I'll be filing that today. I just found it after hours.
Have you done it?
No, I have not yet.
You haven't done it, you can't argue it.
Okay, well, it goes along, it's along the same line, so it does.
You can file a supplemental authority after the fact, you just can't argue it now.
Definitely. Well, I will be filing the supplemental authority. And as far as any facts asserted by opposing counsel, it's the same thing they did below, the same way they tried to authenticate the assignment. And they actually distinguish our cases that say that unsworn attorney statements do not establish facts. They actually distinguish our cases because it's foreclosure. So I guess their theory is that if it's a foreclosure case, then attorneys can make unsworn statements that establish facts. But that's just simply not true. And I'm not even sure why it was opposed. And just to get back to the motion said the originals would be filed. It said they would be the note, the mortgage, and the assignment of mortgage. The rule requires them to specify the grounds. Should be reversed. Thanks.
All right, thank you both. That will conclude.
He files a supplemental, can I file a one-page response to it? He handed me the case this morning.
Well, you can't respond because he can't make argument. If you think the case is no good, you can file some other case that you think contravenes it, but you can't argue because he can't make argument in his supplemental authority.
Right, well, then I was wondering, do you take notice of it then if he files a supplemental authority? If you don't read it because it doesn't go into your decision, then I don't need to respond to it. That's why I wondered.
No. You can't argue, you can't come into oral argument and argue a case that you haven't provided supplemental authority, but we're not bound by the cases that you all cite, period. And if he cites the case and we thought we wanted to cite it in our opinion, we certainly could do that.
I'm just wondering if he sends it in the...
I would suggest if he files a supplemental authority and you think that there is a case that says something to the opposite...
No, I wanted to distinguish that one.
Then you can cite the distinguishing case. But he can't make argument in his notice of supplemental authority. All he can say is, here's a case and it's relevant to point 2 on appeal.
I understand.
And you can file something that says, here's a case that is relevant to point 2 on appeal.
Well, Your Honor, to distinguish, this is after the briefing schedule closed, so this is not...
Okay, that's what supplemental authority is for. Okay.
Supplemental authority.
All right, thank you so much.
Thank you.